3. Specifically, a new trial is required in this matter based on the following factors. A. It is in the interest of justice. B. The verdict is contrary to the weight of the evidence presented at trial. C. New evidence and material has recently been discovered which probably would produce a different result at a new trial, and by reasonable diligence, such evidence could not have been discovered sooner. D. Witnesses necessary to establish Carly's defense were improperly excluded from testifying at the trial.
What is this new evidence? What her dad slipped up and said during his interview?
Did not receive a fair and impartial trial. 4. A new trial is in the interest of justice for several reasons. Carly was not tried by a jury of her peers. Carly was 15 years old when her trial commenced on September 16th of 2024. Mississippi requires a person to be age 21 and older.
15-year-olds cannot be on a jury. That is why she was not tried by her peers.
To talk to the state, refused to talk to the mental health professionals evaluating Carly, and refused to come to any pretrial hearings or a single day of Carly's criminal trial. This new information supports Dr. Clark's diagnosis of unspecified schizophrenic disorder and is likely to lead to a different result at a new trial. As such, Carly is entitled to a new trial. 7. Carly timely disclosed her witness list to the state pursuant to the timeline established by the Mississippi Rules of Criminal Procedure. Carly produced her witness list to the state on September 3rd, 2024, 13 days prior to trial. Carly's witness list was comprised of 9 total witnesses and 1 witness who would testify only at a pretrial hearing. All of the witnesses listed were known to the state prior to the production of the witness list. 8. The state's witness list was produced to the defendant on September 8th, 2024, 8 days prior to trial. It was comprised of 55 witnesses. The state's amended witness list was produced to the defendant on September 9th of 2024, 7 days prior to trial. It was comprised of 57 witnesses. Hey, check this out. Willful discovery violation motivated by the desire to gain a tactical advantage at trial. As a result, the court struck 2 of the defendant's witnesses and restricted the testimony of the remaining defense witnesses. The 2 witnesses struck by the court were both immediate family members of the defendant, both of whom had both spoken to law enforcement as early as March 19th and March 22nd of 2024. Both witnesses were present during at least one of law enforcement's searches of the crime scene. The state never contacted either witness, never requested a continuance, and interviewed several of the defense's remaining witnesses. Moreover, this case was tried less than 4 months following the indictment and 6 months after the incident occurred. There was sufficient time for either the defense or the state to gain a tactical advantage at trial. Important trial evidence was still being produced in response to subpoena in the weeks leading up to the trial. 9.
What do y'all think?